The threat is stopped. Your hands shake. Your heart pounds. Sirens approach. And what you say in the next 60 seconds determines whether you go home or spend 20 years in prison. Every day, people who successfully defend their lives destroy their legal cases in the first minute by making one catastrophic mistake prosecutors use to turn justified self-defense into murder. The trigger? When police arrive asking what happened, most people's instinct is explaining everything immediately. They think cooperation means conversation. This is the most dangerous assumption possible. I've analyzed over 600 self-defense cases where justified shootings became murder convictions. I've reviewed interrogation transcripts and examined research on how stress destroys memory accuracy. After studying case law from 40 states, I've identified the traps that turn survivors into defendants. I'll show you 4 deadly mistakes people make after self-defense shootings, why your brain can't give accurate statements immediately, and 3 words that protect you legally. This is educational content only. Consult a licensed attorney for your situation. Mistake number 1 is giving detailed statements at the scene. The moment the threat stops, most people want to explain. They think explaining immediately proves innocence. This is the most dangerous thing you can do. Picture this. You survived an attack. Attacker is down. You're breathing hard, hands trembling, adrenaline flooding. Police arrive asking what happened. You start talking. He came at me with a knife. I told him to stop. He kept coming. I was in fear. I fired 3 times, maybe 4. He was about 10 feet away, or 15. It happened so fast. What people believe? Immediate cooperation shows innocence. Explanations help. Make police understand and go home. This is backwards. The legal reality. After deadly force, your brain is physiologically incapable of accurate memory. Adrenaline floods your system. Your amygdala hijacks cognition. Time distorts. Memory gaps form. Your brain fills gaps with false memories that feel real. Force Science Institute research on officer shootings found memory consolidation after extreme stress takes 48 to 72 hours minimum. Your brain needs 2 full sleep cycles to properly encode traumatic memories. Before that, your statements contain errors and contradictions that feel absolutely true, but aren't accurate. Dialogue that destroys cases. Officer, what happened? Shooter, he attacked me. I shot him 3 times. Officer, how far away? Shooter, about 10 feet. Officer, were you in fear? Shooter, absolutely. Officer, warnings? Shooter, yes, I yelled, stop. 48 hours later, after adrenaline clears, you remember differently. He was 20 feet. You fired 5 times. You're unsure if you yelled. These contradictions become consciousness of guilt evidence. Prosecutors play your scene statement. Show how later testimony conflicts. Argue you're lying. Fabricating self-defense. Body cameras record everything. Your scene statement becomes locked testimony. Every word, detail, emotion gets preserved. When memory clarifies and details change, prosecutors use contradictions to destroy credibility. Even truthful people become impeachable when they talk too soon. The correct move. After calling 911 and identifying as victim, provide only 5 critical pieces. 1. I am the victim. I was attacked. 2. Point out attacker and weapons. 3. Point out evidence. 4. Point out witnesses. 5. I will cooperate fully after I speak with my attorney. Nothing more. When officers ask details, repeat calmly. I want my attorney. I will give a full statement after consulting with counsel. Why it works? You've identified as victim, preserved evidence, demonstrated cooperation, but you haven't locked yourself into a statement your brain cannot accurately give. Under Salinas versus Texas, silence after explicitly invoking rights cannot be used against you. The bottom line, Never give detailed statements at the scene. Your brain physically cannot produce accurate testimony in the first 48 hours. That protects you from adrenaline-fueled errors. But here's what most people don't realize. Even if you stay quiet at the scene, the psychological pressure in interrogation breaks people down. Mistake number 2 is talking during interrogation before consulting an attorney. Mistake number 2 is answering questions during interrogation. After people successfully stay quiet at the scene, they get to the station and break. Detectives are trained interrogators. They know exactly how to exploit your emotional state. And this is where legally justified shootings become murder charges. Picture this. You're at the police station. You've been there for hours. You're exhausted, traumatized, emotionally drained. A detective sits across from you and says, "Look, we know you were defending yourself. We just need to understand what happened. If you were really in fear for your life, just tell us. Help us help you." The longer you stay quiet, the worse this looks. What people do wrong, they break. They think the detective is on their side. They think explaining will help. So they start talking. "I really was in fear. He came at me. I didn't want to shoot. I had no choice." Every word builds the prosecutor's case. The legal reality? Detectives are not on your side. They are evidence gatherers. Their job is to build a case. When they say, "Help us help you," they mean help us gather evidence against you. Everything you say gets recorded, transcribed, and handed to prosecutors who will spend months finding every contradiction, every inconsistency, every word they can twist. The interrogation tactics are sophisticated. Detectives use the Reed technique, a systematic method proven to produce confessions even from innocent people. They minimize the moral weight of what happened. Anyone would have done the same thing. They offer justifications. You were scared, right? They suggest you'll feel better if you just explain. Every one of these tactics is designed to make you talk. The dialogue that convicts? Detective: "Were you scared?" Shooter: "Yes, terrified." Detective: "Did you think he was going to kill you?" Shooter: "I don't know, maybe." Detective: "So you're not sure?" Shooter: "No, I thought so at the time." Detective: "But you just said you don't know." Shooter: "I was scared. I wasn't thinking clearly." Detective: "So you shot him without thinking?" The detective just got you to admit you weren't sure about the threat and that you acted without thinking. Those statements will be read to a jury as evidence you didn't have reasonable fear and you acted recklessly. Even though you were trying to explain legitimate fear, the interrogation twisted your words into admissions of guilt. Court precedent is clear. In Berghaus v. Tompkins, the Supreme Court ruled that remaining silent isn't enough. You must affirmatively invoke your right to counsel. Once you invoke, questioning must stop. But if you voluntarily start talking, every word is admissible. Detectives will pressure you, but the moment you say, "I want my attorney," legally, they must stop. The before and after contrast: wrong way. Detective says, "Just tell us what happened." You respond with any explanation, and you've given them ammunition. Right way. Detective says anything, you respond, "I am invoking my right to remain silent, and I want my attorney present." He continues pressing. You repeat the exact same phrase. He suggests you look guilty staying quiet. You repeat, "I am invoking my right to remain silent, and I want my attorney present." The legal protection. Under Miranda and its progeny, once you unambiguously invoke your right to counsel, interrogation must cease. Under Edwards v. Arizona, police cannot reinitiate questioning after you invoke counsel unless you voluntarily reinitiate contact. Statements obtained in violation of your invocation cannot be used at trial. The bottom line? Do not answer questions in interrogation. Invoke your right to counsel explicitly and stop talking completely. You've stayed silent at the scene and invoked rights during interrogation. But here's the trap most people miss. Thinking your right to silence means you say literally nothing. Mistake number 3 is failing to make the minimal critical statements that preserve your self-defense claim. Mistake number 3 is staying completely silent at the 911 call. There's a critical difference between giving detailed statements and making the minimal factual assertions that frame the incident as self-defense. Some people stay so silent they destroy their own defense before it begins. Picture this. The threat is stopped. You need emergency services. Someone calls 911. The dispatcher asks questions, and you say absolutely nothing. Or you say, "Someone's been shot. Send police." Then you hang up. No mention that you were attacked. No mention that you defended yourself. No mention that you're the victim. What people get wrong, they think any statement to police can be used against them. So they say nothing. Or they panic and only report the shooting without context. This makes you look like the aggressor. Prosecutors argue you tried to hide what happened. Juries hear that guilty people minimize their involvement while innocent people immediately report being victimized. The legal reality, the 911 call, is recorded. It's evidence, but it's evidence that cuts both ways. If your first words to police establish you as the victim who was attacked and forced to defend yourself, that recording supports your self-defense claim. If your first words are just, "I shot someone," that recording sounds like an admission of guilt. The correct minimal statement on 911. "Someone attacked me. I was forced to defend myself. I need police and medical. I am the victim. Send help immediately." Give your location. Describe what you're wearing so police don't mistake you for the threat. If someone else can make the call, even better. But those minimal facts must be established. Why this works? You've established the essential elements of self-defense. You were attacked, you were the victim, you were forced to defend yourself. You haven't given details that can be contradicted later. You haven't described your emotional state in ways that can be twisted. You've simply framed the incident accurately as self-defense from the first moment. The dialogue example: Dispatcher: 911, what's your emergency? Caller: Someone attacked me. I was forced to defend myself. There's been a shooting. I need police and medical immediately. Dispatcher: Are you injured? Caller: I'm not injured. I am the victim. I need my attorney. Please send help. Dispatcher: Can you describe what happened? Caller: I am the victim of an attack. I defended myself. I will give a full statement to police after I consult with my attorney. Please send help now. This framing establishes your claim without giving details that can contradict later memory. Most importantly, research shows that even police officers involved in shootings are advised to wait 48 to 72 hours before giving detailed statements. If trained law enforcement personnel need time for memory consolidation, civilians absolutely need that same protection. The bottom line: make minimal statements establishing you as the victim at the 911 call. Nothing more. Defer details until you've consulted counsel. You've made minimal statements establishing victimhood and invoked your rights. But here's the misconception that destroys cases even after everything else is done right. Mistake number 4 is thinking this advice means you shouldn't cooperate with police. Mistake number 4 is confusing silence with non-cooperation. People here don't talk to police and think that means being hostile, evasive, or uncooperative. This is wrong and dangerous. You can and must be respectful and cooperative while still protecting your rights. The legal reality: cooperation and conversation are not the same thing. Cooperation means following lawful orders, providing identification, allowing processing, and agreeing to give a full statement after consulting an attorney. Conversation means answering questions about the incident, explaining your actions, and providing details. You must do the first, you must not do the second until you've had time to let adrenaline clear and memory consolidate. The correct approach after invoking rights: when police say anything, respond politely. Officer, I want to cooperate fully. I will give you a complete statement after I've had the chance to consult with my attorney and after my memory has had time to settle. Even police officers wait 48 hours after critical incidents. I'm asking for that same consideration. This does several things legally. You've demonstrated willingness to cooperate. You've explained your silence reasonably. You've compared yourself to police officers, which creates sympathy. You've referenced the scientific basis for delayed statements without sounding like you're hiding something. Most importantly, you've remained polite and respectful, which matters enormously in how police and prosecutors view your case. The practical reality: in most jurisdictions, you will be detained after a self-defense shooting. This is standard procedure. Police will investigate. You may be arrested and held for up to 48 hours. This happens even in clean self-defense cases. Being detained is not evidence of wrongdoing. It's part of the investigation. Your job during this time is to remain calm, be polite, invoke your rights, and wait for your attorney. What actually protects you after deadly force? Call 911 immediately and identify yourself as the victim. Make the 5-point minimal statement at the scene. Invoke your right to counsel and right to remain silent explicitly. Be polite and cooperative with processing. Do not answer detailed questions about the incident. Contact your attorney as soon as possible. Write down everything you remember once you're alone. Wait at least 48 hours before giving any detailed statement to police. State-specific considerations. Some states like Florida have immunity hearings where you must prove self-defense before trial. Other states put the burden on prosecutors to disprove self-defense. Some jurisdictions arrest in every shooting, others don't. Know your state's laws before you carry. Have an attorney identified before you ever need one. Consider legal defense insurance that provides immediate attorney access after critical incidents. The bottom line: silence is not non-cooperation. Invoking rights is not evidence of guilt. Cooperation means following lawful orders while protecting your constitutional rights to counsel and against self-incrimination. Here's the core principle. The most dangerous moment after a self-defense shooting is not the attack itself, but the first 60 minutes afterward, when adrenaline and stress impair your memory and judgment and people instinctively start talking. Police arrive to collect evidence and identify suspects, not to decide who was morally right. Anything you say, even if truthful, will include inconsistencies that later undermine your self-defense claim. Silence isn't guilt. It's a strategy that protects your rights, allows your body and memory to stabilize, and ensures your lawyer can help you avoid turning a survivable situation into a long-term criminal case. Remember the 3 words that actually protect you. I want counsel. Not I want a lawyer eventually. Or maybe I should talk to someone. Explicitly and clearly, I am invoking my right to remain silent, and I want my attorney present now. These 3 words end interrogation. These 3 words trigger your 5th and 6th Amendment protections. These 3 words give your brain time to recover from adrenaline and consolidate accurate memories. Your practical next steps. First, identify a criminal defense attorney who handles self-defense cases before you ever carry a firearm. Have their number saved. Consider legal defense insurance. Second, memorize the 5-point scene statement. I am the victim. Point out attacker and weapons. Point out evidence. Point out witnesses. I will cooperate after speaking with my attorney. Third, understand that even justified shootings result in investigation, possible detention, and traumatic legal processes. Accept this reality now, so you're prepared. Fourth, train not just marksmanship, but also post-incident procedures. Know what to do after you're forced to defend your life. This is educational content only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. If this video helped you understand your rights after a defensive encounter, hit that like button. Subscribe to this channel for more legal breakdowns that could save your freedom. Click the bell so you don't miss future videos. Share this with anyone who cares for self-defense because everyone needs this critical knowledge. You've learned how to protect yourself legally after defending your life, but understanding post-incident procedures is just one part of self-defense law. There are other critical legal principles about when you can use deadly force, what constitutes reasonable fear, and how to avoid criminal liability before a shot is ever fired. I've got comprehensive legal analysis of those defensive force standards in the next video. It covers the legal framework that determines whether your use of force was justified in the first place. That legal education is on screen now. Watch it to complete your understanding. Stay safe, know your rights, and remember, the right to remain silent is the most important right you have after defending your life.